Hi, and welcome to this week's bonus materials. I'm Nick Crown.
And I'm Bradley Silverman.
We're both going to talk a little bit about the Constitution in real life. We've talked a lot during the course of the bonus materials, and Professor Mars discussed the Constitution in the abstract. But we're going to talk about the Supreme Court today and how it makes decisions on constitutional cases. So when the Supreme Court gets a case, it actually doesn't have to accept the case on its merits unless it wants to. It's called discretionary review. So what happens is, if someone gets a case that they don't agree with in an appellate court, they can file a writ for certiorari, or a cert petition. They'll ask for a writ so that the court will actually hear the case and then maybe decide whether or not the appellate court below correctly decided the case. Now, the number of cert petitions each year is around 10,000. So courts around the country issue opinions, and then very often the loser will then petition to the Supreme Court to rehear the case. The actual number of cases that the court decides each year is much lower. Today it's about 75 to 80 cases that the Supreme Court will decide on the merits. That is, the court will look at the arguments that the parties have presented and reach a conclusion based on those arguments. Basically what happens is the Supreme Court will grant the writ for certiorari, and then the parties will write briefs. They'll present their arguments in written form. The court justices will read those briefs, their clerks will read the briefs, and then they'll hear an oral argument most often. And then at the oral argument, each side gets to present their arguments to the 9 justices on the Supreme Court. The court will then adjourn, they'll have a conference and talk about the case a little bit, and then they might give a vote of how they would rule in that case. Then the justices will go back and they'll write an opinion. Sometimes all 9 justices will agree and there'll be one opinion for the court, or sometimes the justices will have disagreements and there might be one main opinion, a concurring opinion, or if someone disagrees and is in the minority, they might write a dissenting opinion. And those opinions are then published to the public, and that's actually how we get a lot of our constitutional law. The court will interpret these different cases or provisions from the Constitution and come up with rules and holdings that we then abide by.
I'd like to make 2 notes on the cert process. First is, this is one where the appellate courts really have a lot of power, because for the overwhelming majority of cases that are heard in the appellate courts, the appellate decision is the last stage in the process. The court very rarely grants cert on a case, so for most parties who go to court, their journey ends at the appellate level. That's part of the reason why when the president nominates someone to one of the Court of Appeals, it's a very high-profile nomination. These oftentimes spark a lot of fights, very careful scrutiny of the nominee, because these are very important positions. Mm-hmm. For most cases, the appellate judges are really the ones who, in effect, make the law. And the other distinction I just want to hone in on is, what exactly is a concurring opinion? There are really 2 different types of concurring opinions. One is where a justice will say, I agree with the majority, and in addition, I would also say this. Maybe I would reach the case for this reason, I would reach the decision for this reason, or I would go further than the majority goes, or I would do a little differently. Then there's another type of concurring opinion that basically disagrees with the majority's reasoning, reaches the same result for an entirely different reason. Maybe the majority says the government lacks the power to do something. And a concurring opinion might say, well, I actually think the government has the authority to do this, but I think there's an affirmative provision in the Bill of Rights maybe that then blocks it from doing it. So there can be subtle or enormous distinctions in the logic of a concurring opinion and a majority opinion.
Yeah, those are great points. I guess a follow-up question actually, Bradley, would be, do you know how many circuit court judges there are? So you mentioned that the appellate judges are very, very important. I think there's, around 200 judges that are on the Circuit Court of Appeals?
I think there are more than that.
Is it really?
This is not something we should include because we don't know the numbers.
Yeah, I just thought actually.
No, I wish I knew that. Cut this part.
All right. No, those are great points, Bradley. I think especially with the concurring opinions, it can make a big difference too, depending on how the decision comes forth in an early case. If you have a concurring opinion later on, maybe a few years later, even decades later, a new justice might pick up on a concurring opinion and then refashion that as part of a new decision.
And that's true of dissents as well. Sometimes the dissent in one case will decades later become the majority opinion in another case. Brown v. Board of Education is a great example of that. In 1896, the court heard a case called Plessy v. Ferguson, where they said that separate but equal is the law of the lands. And one justice dissented and said our Constitution is colorblind, separate but equal is inherently unequal. And then in 1954, the court in Brown v. Board of Education basically took the dissenting judge's opinion and turned it into the majority opinion.
I think that was Justice Harlan.
It was.
And you might have noticed, Professor Amar might have mentioned this in the lectures. He says that Plessy v. Ferguson was wrong on the day it was decided, and part of the evidence he uses for that claim is that you had the dissenting opinion from Justice Harlan.
Yeah.
So that just highlights how important these opinions are all published in the U.S. reports, and it just shows that those U.S. reports are very long-lasting because an opinion that's 80 years old can still come back and be something that will make new law.
One other point to make is, in some cases, you'll actually have the court failing to reach a majority. Maybe 4 justices will think one thing and 4 justices will think another thing, and then you'll have one justice who agrees with the first group on some points and agrees with the second group on other points. And so you can reach a result that no one except for that one justice is really happy with, because on issue 1 he sides with group A, and on issue 2 he sides with group B, and so the guy in the middle may be the only one who's really satisfied with the result. So sometimes when there's no clear majority, you have to try to figure out which position would have gotten the agreement of a majority of justices on the court. So usually that's the most narrow position available on a certain issue.
Two points on that. The justice nowadays who's often the one that's that single justice is Justice Kennedy, right?
Oh boy, is he, yeah.
Yeah, so he's the justice that sometimes will join the liberal wing of the court and sometimes will be more with the conservatives, and he's the one that will swing back and forth sometimes.
A lot of Supreme Court brief writing is really aimed at getting Kennedy's opinion.
The second point is, I think, when you have those kind of opinions where 4 justices agree, a lot of times that's called a plurality, right? Where the justices will agree on the result, but they'll disagree on the reasoning of how they got to that result. So when you have a plurality opinion, sometimes it's not quite as binding when you get to the next case. So when you have a 5-4 majority, or just any majority, everyone agrees on the reasoning, you're going to have pretty strong precedent. So for the next case, you'll be able to cite to that and say, look, a majority of the court held X. But then when you have a plurality, it's a little more difficult because they'll be able to argue in a later case, well, this is the result they reached, but the reasoning itself is not set in stone by any means.
Reasoning is only binding if it is shared by a majority of justices on the court, which is why when there are only plurality opinions, when there are 4 justices think one thing and 4 think another thing and 1 thinks something else entirely, it's really important to try to figure out what narrow strand of reasoning connects the one justice to the other 4.
Well, should we move on to some actual cases? So there are 2 cases that I think we'd like to highlight in this segment. The first is Holt v. Hobbs, which is a case that was recently argued in front of the Supreme Court. And the second is Elonis versus United States, which is a case that will be heard in December.
So let's discuss Holt first.
Sure.
So Holt v. Hobbs involves a challenge brought by an Arkansas state prisoner to a certain policy, a certain Arkansas state prison policy concerning prisoner grooming habits. So the issue there is there's a prisoner who, due to his religious beliefs, believes that he must be able to grow his beard out to a certain length. He says his religion requires him to grow a beard that is at least 1 inch long, but he's willing to compromise and grow a half-inch beard. Under Arkansas state policy, though, prisoners are not allowed to grow facial hair at all unless they have certain skin conditions, in which case they can grow a 1/4 inch beard. And so ordinarily this might not be an issue, but for a federal statute called RLUIPA. And RLUIPA stands for the Religious Land Use and Incarcerated Persons Act. And what it does is it establishes basically a higher burden for laws that infringe upon a prisoner's religious exercise. So there's a little bit of back history to this, and involves a case you might have heard of called Hobby Lobby. That was the contraceptive case that the Supreme Court decided last summer. So the rule that the First Amendment establishes is that a law of general applicability is binding on everyone, basically, regardless of their religious beliefs. So if there's a law that has the effect of maybe burdening your religious practice a little bit, as long as the law doesn't single a religious group out and it has a valid secular purpose and isn't just designed to pick on one religious group or doesn't have the purpose of burdening religious practice, then you have to adhere to it.
If I could interrupt just there, I think there was a Supreme Court case where an example where it was particularly focused on one type of religious group was a group that did animal sacrifice, I think.
Yeah.
And the law was saying you cannot have any sort of animal sacrifices, and it targeted the specific religious activities that were going on. So that's, I think, what the law is.
And even under the very deferential test, that kind of law would be unconstitutional because this is singling out a religious group for the purpose of singling out a religious group. But there are other types of laws. Let's say, for example, a state has a statute prohibiting people from smoking peyote. And this actually was brought up in the case Employment Division v. Smith, where the state law prohibited smoking peyote, and a person brought a challenge to that law, saying that he was denied certain state benefits because he smoked peyote, and so he challenged the law and said this violates my religious practice. And in a 1990 opinion written by Scalia, actually, the court said no. It doesn't matter that this law has the sort of incidental effect of burdening your religious practice because it is a law of general applicability. It's neutral. There's a legitimate purpose that goes beyond just wanting to burden your religious exercise, and so too bad. So in response, Congress passed a law called the Religious Freedom Restoration Act, which basically set up a three-part test for all laws that burden religious practice. The first step is to decide whether or not there actually is a legitimate religious practice that is burdened by the law. So if you're just making it up, if you're saying, oh, this thing I don't want to do it burdens my religious freedom, if you're not sincere, then that's not going to fly. But if there's a legitimate religious practice that is sort of under attack by some neutral law, the next step is to figure out whether the state has a compelling interest for enforcing that law. And if the interest is trivial or if it's not important, then the challenger wins. If the law is important, though, and most laws or many laws have pretty important purposes, so oftentimes the government can meet that test. The third prong is really interesting because even if you have a legitimate religious practice that is burdened by a law, but there's a compelling purpose for that law, the third step is figuring out whether the law is narrowly tailored to achieve that purpose. So the idea is that even if a law does something that governments are allowed to do, it needs to do it in a way that basically impinges upon one's religious practice as little as possible. And
I think the term in the statute, RFRA, the Religious Freedom Restoration Act, was the least restrictive means.
Least restrictive means, yeah. That's a test you actually see a lot in constitutional law. So if there's basically a better way to achieve this purpose that doesn't involve burdening religious exercise, then the law fails. The Supreme Court said that this law, the Religious Freedom Restoration Act, can only apply against the federal government. And so after that happened, Congress passed a new law, RLUIPA, that applies against the states, but only in certain very narrow contexts. And one of those are laws concerning prisoners. So the prisoner brought a challenge to the Arkansas state policy, said that it violates his religious exercise. The state of Arkansas responded saying, well, actually, there's a compelling interest here, and there's no better tailored way of achieving this achieving this compelling state interest. Now, this may sound a little familiar to you because a very similar debate came before the court recently in the Hobby Lobby case. And do you remember Hobby Lobby?
I do, yeah.
So Hobby Lobby concerns a provision of the Obamacare law that required employers to ensure that their female employees had access to contraception. And a religious employer sued, said that this violated his religious beliefs, and the court basically said that for certain types of corporations that are what are called closely held corporations, that are owned by people with sincere religious beliefs, and for those corporations, if complying with the contraceptive mandate would violate their faith, they don't have to do that. And so the law at issue in Holt v. Hobbs it's a different law, but it's basically the same question, very similar question. So Nick, what do you think of this case?
Well, actually, I think one interesting thing was in the oral arguments, the justices asked, can it be this easy? They actually suggested that maybe the case is too easy and there might be something else going on. So it seemed that the petitioner, the prisoner, had a very, very strong argument.
Yeah.
But the justices seemed a little concerned, essentially with, okay, if we say that, yes, this prisoner can grow a half-inch beard, according to your religious beliefs, well, isn't the next case just going to be about a prisoner who wants to grow a 1-inch beard? And after that,
2-inch beard,
1.5-inch, 2-inch, and where's the limiting principle? When does it get too far?
Yeah.
So I wonder what your thoughts on that particular issue with this limiting principle. Would it be too much for the court to say, yes, you can have a half-inch? Should the court say that there are any lines, or should it try to just approach each case that comes before it one by one?
Well, limiting principles are something that you'll often see the court concerned with. In the Obamacare case, the original Obamacare case, the court basically expressed the concern that if you can make individuals purchase health insurance, what can't you make them purchase? Where's the limiting principle there? So oftentimes, even when the underlying logic seems sound, a court may be concerned just that this principle taken to the extreme can lead anywhere, and maybe we're not comfortable with that. So I don't really know where the limiting principle is here. Partially, it's because the statute is written in a very broad way. There doesn't seem to be a natural limiting principle in the text. Maybe the court can construct one out of legislative history or prudence or constitutional structure. You don't know. This does not seem to be something that really concerns them in the Hobby Lobby case. The same issue was presented there, and the court did not seem to think that exempting religious employers from the contraceptive mandate would pose some sort of slippery slope problem. But it'll be interesting to see this time whether they think that actually there does need to be some limit. This actually raises what I think is potentially an even more interesting question. This is not the one the court is considering in Holt v. Hobbs, and it did not consider this question in Hobby Lobby, but it's fair to ask whether the RLUIPA, the law at issue, is actually unconstitutional in that it favors certain religions over others. The argument would go something like this. The First Amendment contains a clause saying that Congress shall pass no law respecting an establishment of religion. And so one can say, well, what RLUIPA does and what RFRA does are they create special legal entitlements to not have to follow the law that everyone else has to follow. And the people who get these special immunities get them because of their religion. So basically, you're giving certain people a break from following the law purely because they happen to have a certain religion. And that makes a lot of people very uncomfortable. And so the argument is, well, the government can't burden anyone because of their religion, and it also can't give people special benefits because of what their religion is. Now, the court is not considering this question in this case. It may consider it at some point in the future. In about 15 years ago, one justice in an unrelated case suggested, in his dissenting opinion, suggested that this type of law is unconstitutional precisely because they favor religion over non-religion or favor certain religious adherents over other religious adherents. So
that's an argument that's been picked up, I think, a lot by law professors, too.
Yeah.
So in the Hobby Lobby case and in Holt v. Hobbs, you had professors that would write what's called an amicus brief.
Right.
Basically, the two main parties in a Supreme Court case will write their briefs.
Yeah.
But then with the leave of the court or with the permission of one of those parties, they can have their friends of the court or an amicus write a brief.
Parties.
Yeah.
Parties that have some sort of stake in the outcome.
So often there are going to be religious groups or maybe In the Hobby Lobby case, it would be other people who are employees of corporations, or
Industry
maybe
groups,
an
maybe.
industry group.
Maybe the insurance companies will say, hey, we kind of have a stake in this outcome because this will affect this will affect who's paying, and this will affect what services we have to provide. So we're going to chime in. Law professors frequently write amicus briefs as well.
So those Establishment Clause arguments is something that has appeared in those amicus briefs.
Yeah. Now, as far as the issue that's actually at play in Holt v. Hobbs, I don't really know how they'll decide. My intuition is that the way that RLUIPA is written, it's sort of a check off the boxes exercise. There's the question, is there a legitimate religious practice here? I don't think anyone disputes that there is. The government is not arguing that. The real issues come in at steps 2 and 3. The second, is there a compelling interest in this government policy? And so one issue that's presented in Holt that wasn't presented in the Hobby Lobby case is the extent to which the court should give deference to the opinions of the government. In this case, it's the Arkansas state prison system. To what degree they should defer to their judgment that a policy actually is compelling.
And one interesting wrinkle on that is, how do you define the deference, especially considering that we're talking about one state? So one of the arguments that showed up in the oral arguments was, well, Arkansas might be in the minority when they have this rule, but is that even important? Because should we defer to Arkansas as its own state, or should we consider what the general practices in the entire country are?
I believe Arkansas is one of only a very small number of states. 44 states plus the federal government have declined to adhere to Arkansas's very strict rule for prisoner facial hair. Most states are more allowing in terms of letting their prisoners grow out their hair. But you can argue that, well, look, maybe Arkansas is more cautious than those states. Maybe those states have certain policy rationales for their rules, and Arkansas has chosen to try to vindicate different policy choices, and maybe that's okay. Maybe the court shouldn't actually really care whether Arkansas thinks it's an important policy and should decide for itself, or maybe the experience and the expertise and the on-the-ground knowledge of the Arkansas state prison officials should really guide the court's decision. Interestingly, the United States, which is not a party to this case, has filed basically an amicus brief arguing against Arkansas's position, arguing that the law should be, the policy should actually be struck down.
So what do you make of the least restrictive means argument? So there's, even if there is a compelling interest on having this rule saying you can't have these beards in a prison, do you think that's the least restrictive means to have a blanket ban with the only exception being for a skin condition?
Well, it's tough to tell because there are a few arguments put forward by the state of Arkansas. One is that you can hide maybe a small weapon or maybe a SIM card or maybe drugs in a bushy beard. The petitioner here argues that you could comb the beards. You could do a daily beard inspection. Another argument Arkansas puts forward is, let's say a prisoner escapes and they shave their beard. Well, then it can be hard to for authorities to identify them and for the public to notice them and to report them. But the petitioner says, well, you could take pictures of them with the beard and without the beard. So this really shouldn't be a problem. I think there are other things that the state of Arkansas can do. It can just have daily or twice daily or weekly or whatever beard inspections. It can take pictures of prisoners with and without the beards, but at some point this becomes too burdensome, and the overall sort of rationale behind the policy is thwarted. In this case, it's a close call. I'm not really sure I know how the court will decide.
Should we move to the next case?
Yeah.
So the other case that we thought to highlight is Elonis v. United States, which is similar to the Holt v. Hobbs case. It's a statutory case, but it also includes some First Amendment issues as well. So in Elonis, at the heart of this case is a federal statute, 18 U.S.C. section 875, subsection C. The U.S.C. is the United States Code, so it's a criminal law that was passed by Congress. And basically what that statute does is it says it's a crime to transmit in interstate commerce any communication containing any threat to injure the person of another.
Basically, you can't threaten another person, or at least you can't threaten another person in a way that crosses state lines.
So I guess the first connection that we can draw with Professor Amar's lectures is where it says here in the statute to transmit in interstate commerce. So right there, it's what we can call a jurisdictional hook. So as you might recall, Professor Amar mentioned that there's this commerce clause that allows Congress to regulate affairs between states. And by limiting the statute to any sort of threat that is transmitted in interstate commerce, it gives Congress this authority, this jurisdiction over this type of activity. So the threat has to be crossing state lines in order for the statute to apply.
Professor Amar likes to argue that we shouldn't think of the Interstate Commerce Clause as the Commerce Clause, we should think of it as the Interstate Clause, because Professor Amar will say there are national problems and there are federal problems, and these are two different things. A national problem is one that occurs everywhere across the country, but doesn't require a solution from the federal government. It is one that the states themselves are competent to take care of. And the example he likes to give, and over again, is bratty children. He says bratty children is a national problem. They're everywhere, and they're a real menace. But it does not require federal action to take care of bratty kids. This is something the states can do themselves, or arguably maybe even parents can do themselves. Whereas a federal problem is one that, because it crosses state lines and it occurs in more than just one state, no one state is really able to take care of the problem on its own. It extends beyond the state's reach.
So an example would be if someone from Texas sends out a threat to someone in Connecticut, where we are now, that's something that would involve two states, so maybe it's better for the federal government to get involved.
Interstate crime, maybe if you're engaged in a criminal enterprise and you flee across state lines, well, the state police, their jurisdiction really ends at the state border, but the other state can't reach back into the first state, and it can be very challenging for one state to try to solve a problem that extends beyond the state's border. As an aside, just one example of the importance of this jurisdictional hook. In the 90s, Congress passed a law that basically made it a federal crime to bring guns within a certain distance of a school zone. And the court struck this down, saying there isn't an interstate problem here. This isn't related to interstate commerce. This doesn't really cross state lines. This is all local. The states can take care of this, and usually do take care of this. So then Congress basically repassed the law, except this time it added a provision saying that the law only applied to guns that moved through interstate commerce. And the second time around, the court upheld the law, saying this is perfectly fine. This falls within Congress's reach because it only reaches those guns that actually move across state lines.
And it's a formalistic point in some ways, because the same exact guns, the same exact activity that would not have been constitutionally criminalized under the old statute now can be, just because we have that jurisdictional hook.
And in the guns case, there really isn't any evidence that the law has been enforced in any different way under the first or second iteration. There's no evidence that adding the jurisdictional hook has really constrained the reach of the law. But it's a little bit of formalism, and so the court looks at it and says, yep, this is fine.
It's dotting your I's and crossing your T's.
Pretty much.
Yeah. So with the facts of this case in Elonis, it's, again, the threat statute. And what happened was there was a man who had a contentious relationship with his ex-wife, and he started posting on social media, on Facebook. He starts writing some things that actually started worrying the ex-wife and some of her friends.
Very scary things.
And they were some pretty scary things, but the defendant in this case was also writing things almost tongue-in-cheek with the way he was presenting them. At one point, he had an order against him saying that he could not bother his wife, essentially, but then he would write on Facebook saying, it would be very illegal for me to, and then he writes all these things that are a little harrowing.
It would be very illegal to threaten my wife. It would be very illegal to say that from this vantage point, you would have a clear shot through the window. It would be wildly illegal to suggest that you do this, things like that. This guy's trying to be a little too cute.
So he's writing these things on the internet, and with this jurisdictional hook, there's no real question. If something reaches the internet, then it's going to be accessible by people from all over the U.S., probably all over the world. Yeah. And the key issue in this particular case is, first, whether the statute requires, when someone is transmitting a threat, when that person is writing the so-called threat, or a true threat is the term they use, does that person have to intend the words that he or she is writing to be understood as a threat, or is it enough for the person to write the words, know what the words say, and then some other person, an objective person,
A reasonable person
to read those words and say, that's a threat. So the real question is intent. Does the writer, or the author of these threats, have to intend his words to be understood as threats, or is it enough for this abstract, more objective, reasonable person to understand them as a threat?
Yeah. So just to illustrate this, if I said, hey, Nick, I'm going to kill you, no one's going to really take that seriously. Nick's not threatened. But if I said in a very sort of menacing way, if I threatened to kill you, and I didn't mean it, I didn't actually have, maybe I thought I was joking, maybe I thought I was saying something else, but you really took it very seriously. You became very scared. Well, that's basically the issue here. Would my threat violate the statute? Does it fall within the law's reach? About a decade ago, a little over a decade ago, the Supreme Court handed down a case called Virginia v. Black involving a cross burning by the Ku Klux Klan. And that was basically the case that established this true threat doctrine. It said the First Amendment protects speech, but there are certain categories of speech that do not receive First Amendment protection. When you make a true threat against someone else, well, the First Amendment's not going to save you there. You're not allowed to threaten people. But the case didn't resolve the question of what exactly constitutes a true threat. Is it just what an objective, reasonable listener would think, or does it really matter what the speaker's thinking?
And that's one of the key points in both sides, the petitioner or the defendant in the original case, the person who wrote these words, and then the government defending the statute. They're both arguing on what is the definition of a threat.
Yeah.
And in some ways, to me, it seems like they're almost arguing past each other because they're not agreeing on what a true threat actually is.
Yeah.
And so the government will say, well, this does not violate the First Amendment protection of speech because it's a true threat, and true threats aren't protected.
Yeah.
But then the petitioner will then argue saying, well, no, the very definition of a threat is communicating an intent, that you have to intend what you say in order for it to be a threat. And the government's saying, well, no, you just have to communicate the words, and the words themselves represent an intent, but you don't have to actually have that intent.
Yeah. And there are problems with both of these approaches. So let's say the question is just one of the speaker's intent. Well, one problem with that is it can be very hard to figure out what someone's intent is. And so if I make a statement that comes across as very threatening, and any reasonable person would be likely to think that I'm threatening them, it can be very hard for the government to prove that I really have the mens rea, that I have the state of mind to make my statement culpable. Because in general, proving what's in someone's head is difficult. And if I say, "Oh, I didn't mean it. I wasn't trying to really threaten them. I was joking around, or I was being artistic, or what have you," then there will be a lot of people who will get away with making genuinely threatening statements, and that's obviously problematic.
And on the other side of that same coin is, especially when we're talking about things that are written on the internet or just typed out, it can be really hard to determine what is the meaning of a statement because there's going to be some ambiguity. One of the briefs mentions that we use emoticons or like a smiley face or different types of symbols to represent an emotion because it is so hard to get across a single meaning when you write something online.
Yeah.
So the petitioners argue...
Tone doesn't always come across through text.
Exactly. So
the example I gave before between saying, I'm going to kill you and I'm going to kill you.
Right.
You can hear the difference there, but if I type that out, you won't be able to tell necessarily.
It's very hard. So again, because it's so hard to determine what is the tone of an internet message, it's difficult to say, well, even if everyone agrees that the person did not intend his message to be interpreted as a threat, if a person reading it doesn't catch on that tone, and that's a reasonable person couldn't catch that tone, then the person could still be guilty, even though in his mind he didn't mean to do anything wrong.
Yeah. Another problem with the intent standard is not just that it's hard to figure out someone's intent, but let's say Nick and I both make the same threatening statement to different people. And let's say Nick is really serious and he means it, and I'm just joking around, and the government, concedes that I'm just joking around, but they can prove that Nick meant it. Well, it's a bit of a problem in that you're punishing one person for basically doing the same thing that someone else didn't do, but you're not punishing them. So you have two identical acts that are being treated very differently by the law. you can resolve this by saying, well, they're not identical acts because part of the act itself is the intent. That something that looks the same on the outside actually can be very different if what's going on in someone's head. We should think of this as a categorically different thing. Another problem with the intent standard is that you think about the reason we criminalize threats. It's not just because we don't want people thinking bad things. We criminalize threats because of the effect they have on the listener, because they can induce fear. They terrify people. They make people change their behavior when they think that if they do a certain thing, someone will hurt them, or if they think they go a certain place, someone will hurt them. So whether or not you have the right intent, that may not be very important to the person who's on the receiving end of the threat, because they don't know. They're gonna be terrorized either way.
In that kind of argument, they're saying that the harm is already done, regardless of what the person intended. And there are other types of cases where you have speech that is not protected, or you don't have to prove that the person's intent was involved here. I think a couple examples would be like obscenity cases, or in fighting words cases, where if I say something to incite you, to get you to fight me, that's not really protected.
No.
Even if what I'm saying, I don't intend for you to want to fight me, the damage is already done if that's what I'm doing. If I yell fire in a crowded theater,
that's not protected speech.
Right.
And a lot of this has to do with the need for bright line rules to guide conduct. When you have a sharp, crisp rule that says if you say this, that's not protected speech and you can be prosecuted. Well, people know what to do and what not to do, and they can really they can behave accordingly. But when there's sort of a fuzzier standard, what the person intended, and it's hard to prove, this doesn't really give as much ex ante guidance to people. May not know if they do this or that, whether they'll get away with it. One problem, I've been speaking about problems with the intent-based standard, but there are also problems with the objective reasonable person standard. One is that if you have two people saying the same thing, one means it in a threatening way, one doesn't, and you punish the person who only means it in a threatening way, in a way, the difference between them, the thing you're punishing, is the contents of their head, is what they're thinking. And that's a little troubling, to punish someone just for thinking a certain thing, not entirely for doing something, but punishing them for having a certain thought.
And that's something that shows up in criminal law all the
does.
time, especially with attempt law, where if you and I plan to commit some sort of crime, and we're planning and we don't actually go through with it, we could still be found guilty in some cases, depending on how close we get to completing the event. But there is always that troubling thought of, what if we didn't actually go through with it in the end, and you're still convicting someone for something that they didn't actually do?
We get in a car and we drive to the bank to withdraw some money. That's fine. We go in the car, we drive to the bank so we can go rob the bank. That's not okay. So let's say we decide, let's say our car breaks down while we're going to rob the bank, and so we never actually complete the crime. Well, we might still be charged with attempt. Even though, if you just look at the actual deeds we did, the physical acts that we carried out, that itself is not illegal. It's not illegal to drive to a bank. But because we had the intent of robbing the bank, we can be prosecuted for that. So these issues are raised often in the criminal law.
And especially in the threat context, one of the arguments the petitioners raise is, if you have this message that's sent out and he's criminalized for it, if he's saying something to his wife and he doesn't mean it to be interpreted as a threat, but you still punish him, then in some ways that's going to chill speech. And that's one of those buzzwords that comes up in First Amendment law, where you're going to be chilling speech. How much of a concern do you think that is, where if you have this objective standard, a reasonable person standard, it doesn't matter what the person intends, do you think people the next time around will be a little bit more worried and less likely to express their thoughts?
Oh yeah, definitely. That's a real concern in this case, because the defendant wrote his Facebook posts in the form of rap lyrics. And hip-hop is a genre where you can't take everything someone says at face value. It's not every threat, and everything sounds like a threat is really a threat. So there's a huge danger that people will say things that are actually innocent and that actually many people would not understand to be threatening, but some might take it as a threat. And then you can have someone who basically didn't think they were doing anything wrong, and many would argue didn't do something wrong, being criminally prosecuted. It's really a problem with the way we use language, because we don't always have consistent meanings for the same words. People say things and they have different different motives behind them.
Well, maybe the flip side on that too, and this is something that the government raises, is they say, well, it's a little bit more hard to prove a case than maybe what we're describing, because you still have to show that a reasonable person looking at the context in which the statement is made would understand that as a threat. So how much work do you think is being done by this in-context requirement? So some reasonable person or a jury could look at the context and say, well, it's a little different if we're talking about rap lyrics and we see it's in a song versus, okay, here's the defendant and his ex-wife. They've argued before. There's been this type of animosity going on online, and he's still saying things even after a court told him not to.
Yeah.
Do you think that would alleviate concerns, or?
I think it alleviates some of the concern. I think one problem is you don't necessarily always know what society will consider to be reasonable, or more importantly, what 12 jurors in a criminal case will consider to be reasonable. They're, we don't walk around as if we are the reasonable people. Well, we think we're reasonable people, but others might disagree with us. So you can never be totally certain what society in the form of 12 jurors are going to consider to be reasonable. You can oftentimes have a pretty good sense. If I say, good day to you, sir, probably pretty reasonable. If I graphically threaten to murder someone with a straight face, maybe not. But there's a lot of ambiguity between those extremes.
And that goes back again to your point on tone, especially when we're talking about messages sent online, where you can't always tell. And that's another thing that the petitioner raises. There's the risk here of criminalizing misunderstanding. So to go back to a few of your examples, one that's raised in the briefs is, if you and I are in school and we hear a third person on the phone saying, we're going to blow this thing up.
Yeah.
Maybe I will interpret that as saying, oh no, this person is actually going to set off a bomb in school. He's going to blow up the school. And I truly believe that this is going to be a bomb that's going to go off in school. And so I send in a tip to local law enforcement. They come in and there's this bomb threat in the school. But I was doing everything in good faith, believing this was actually a bomb threat. Yeah. Whereas you heard the same exact statement, but you're a little bit more sly and clever, and you realize, no, actually he's talking about how he's going to do really well at a baseball game tonight.
Yeah.
He's going to blow up the scoreboard.
Yeah.
And you know that he's actually talking about a baseball game, but you send in the same exact bomb tip to the police force, just trying to cause some trouble, maybe because, I don't know, maybe you want to avoid a quiz or something.
I would do that, yeah.
And you're acting in bad faith. Well, we would get the same exact punishment under the subjective standard, because a reasonable person wouldn't look at what was our intent. They would look at the circumstances. We made the same exact phone call at the same exact time, hearing the same exact thing.
Yeah.
And I would be a person who was acting in good faith, being found guilty, whereas you would be found guilty, or we both could be found not guilty, when really only one of us should have gotten that result.
So there's a sense that the law should treat us differently there. If I'm not acting in good faith, if I'm just trying to get out of a test and saying something I know not to be, misconstruing something when I know it has a different meaning, I should not get away with that the way you might get away with that if you really think that they're making a threat. And there is just this overarching problem of people knowing that you don't always take someone's words exactly at face value. Commentators have pointed out, when Bob Marley sang "I shot the sheriff," no one really thought that he shot the sheriff.
So, what do you think is going to be the result?
Oh, I don't know. This is a tough one. If I had to wager a guess, I would guess that concerns for bright line rules and administrability will guide the court toward an objective, reasonable person test, and say that the intent is less important than how a phrase might be perceived.
I think I would agree with that. I think a lot of the work is probably being done by the objectiveness aspect of the test, where you have to look at the circumstances.
Yeah.
And again, there are concerns about whether a jury is really going to be able to determine, based on the context, is going to be the best judge or the best arbiter of that kind of context. But that's kind of our system, right? Where
it is.
You have a panel of a couple of people, up to 12, that will be listening to the case and all the evidence, and they have to make their best judgment. But it is a tough case, especially with the court now looking at the First Amendment speech provision and seeming to protect a lot of speech.
Yeah.
And I'm just not exactly sure how they'll go about it.
Well, oftentimes in cases like this, you'll think that what's guiding the justices are these very high-level concerns over the meaning of this clause or that clause, or what rule best vindicates the values of our constitutional system. And that is true. But another concern that they're very conscious of is just what rules are workable. What kind of rules can actually realistically be applied. And so if I had to guess, I would imagine that the difficulty of ascertaining subjective intent of someone who posts a threatening sounding lyric on Facebook will be too much for the court.
Yeah. And again, it is tough to say one way or the other, because that same exact point where it's tough to prove the intent can cut both ways.
Yeah.
Because if it's
This
tough
is
to
a hard
prove,
case. I'm glad I don't have to decide this one.
yeah, because if it's tough to prove the intent, then maybe that's suggesting that the person's intent wasn't really to send that threat.
Yeah.
Or at least to make it appear as a threat or to cause fear in someone else.
Yeah.
Well, it'll be interesting. I think the arguments are going to be the first week of December.
Yep.
And then opinion should come a few months after that.
Looking forward to seeing what they say.
So I think that's it for now. This is week 6 of the 6-week-long course. So we hope that you've enjoyed the course materials so far.
And thank you for tuning in.